One of the best ways to get information across about a topic is going through an FAQ, which you've probably seen on there. It stands for Frequently Asked Questions. But it occurred to me a while ago that when talking about what people need to think about in planning their estates, there are a lot of things people just don't think to ask about. So I call this my RAQ, Rarely Asked Questions. And here I'd like to talk about the top 7 misconceptions, things that a lot of people often assume are true and rarely think to ask about. So I'm supposed to, there we go. So, number 1 is my spouse died without a will, so I automatically inherit everything. Many people actually assume that because they can usually access bank accounts and live in the family house after their spouse has died. They think nothing needs to be done legally, and then 30 years later, the surviving spouse dies. And their family finds that the first one is still on the title for the house, and by the way, he had a child from a previous marriage whom no one can locate, and that child and the 6 other children all own that one half of the house, despite what the will of the surviving spouse says. Title to the house and other property does not just automatically pass to the surviving spouse. Now, I've also got 1B, which is I called the appraisal district and now the tax statements are in my name, so everything's okay. Well, I'm sorry, I gotta break this to you. The appraisal district collects taxes, and all they really care about is who pays them. They do work with filed deeds, but the appraisal district, what they have on their records has 0 bearing on who holds legal title. Number 2, if I want to disinherit someone, I need to leave them $1. People do this all the time. It has become sort of a trope in popular culture that you can't just disinherit a child. There's some legal requirement that they must get something, however small it is. This actually comes from an actual valid idea that if a child is omitted, that means that the testator lacked capacity and that child has grounds to challenge the will. However, doing this is actually worse than doing nothing because that makes that child into a legal beneficiary of your will who is entitled to notice and copies of papers and often will not even accept the $1 anyway. That means unnecessary legal fees. The better course of action is to either A, specifically mention the child and state that it is your intention to make no provision for him or her in your will. Do not say why. Those can be really grounds for a challenge. Or B, in some jurisdictions, not Texas, by the way, you're required to leave an heir something. In that case, you have a no contest clause in your will and leave the child a large enough sum of money to discourage him or her from causing a problem. It needs to be large enough that losing it will make a difference as opposed to $1, which is really just an insult. That practice is also worth considering if you have somebody that might contest the will. Number 3, the will names me as executor, so I can go ahead and handle things. The answer is no. A will is not like a power of attorney. The executor appointed in the will has 0 legal authority to do anything until he or she is appointed by the court. Wills must go through probate to be legally valid and effective. Number 4, mom has a trust. So whenever she died, everything went into the trust, right? Well, there's a lot of advertising out there telling people they need to avoid probate and get a trust in place for your estate planning. We'll go through that in a few minutes, but for one thing that advertising often misses is that for a trust to work, your property has to be transferred into it. And when someone dies, it does not just go there automatically. You will need a probate to make that trust effective. Number 5, now that dad has died, it's our house, so we can just kick our stepmother out of it. Even if the house is dad's separate property, our Texas Constitution gives a surviving spouse the right to occupy the homestead as long as he or she wants to. That's something people need to remember. Number 6, mom told me she wanted me to have her jewelry, so her wishes need to be honored. The only wishes of a decedent, that being a deceased person, that have any legal effect are those contained in a will or a valid trust that property has been put into, period. And a legal will must either be one of two things: A, signed and entirely in that person's handwriting, or B, signed and attested to by two separate witnesses. Even a notarized document claiming to be a will does not count. Number 7, we really do not have a lot of money or property, so we don't need wills or trusts. Frankly, these are the most frustrating situations I run into, and I run into them often. People often do not think planning is necessary. And after mom and dad pass away, you find that their legal heirs are 11 siblings, 3 of whom are deceased, leaving 5 grandchildren, some of whom are minors, and all of whom have to be brought into an heirship and administration proceeding to deal with their house, which is worth maybe $100,000. And it will cost thousands and thousands to jump through all the legal hoops to get this property into an administration, sold, and the proceeds distributed to the heirs, because there are all sorts of safeguards in the estates code that have to be observed. And most often, nobody has the funds to pay for it. Had mom and dad signed proper, simple wills, the probate would be quick, easy, and efficient, and their beneficiaries could get the benefit of their home. Now, these types of situations can be an enormous mess. I tell my clients that in terms of their money, they do not owe their kids anything. They can give all their money to their cat, as far as I'm concerned. But what I think you do owe your loved ones is not leaving a mess behind to clean up when you're gone. I mean, dealing with the death of a loved one is one of the most traumatic things all of us go through during our lifetimes. And adding legal difficulties on top of that takes the stress level up to 11 and can create permanent rifts in a family. So let's see how we can avoid that and how to set things up so your estate is handled the way you want. Now, during the following, what I'm talking about here, when I talk about what happens with or without a will, that means with either a will or a lifetime trust arrangement in place of a will. To save time, I'm just going to call it a will for now, and we'll get to trusts later on. Now, estate planning really concerns only one thing: how your property will be distributed and managed upon one's death. Even lifetime trusts, though there may be other reasons for establishing them, are directed toward that goal. Before thinking about how property might pass either with or without a will, you have to consider what property would be affected. That is, what are probate assets, which are assets that pass through state law rules or through a will's directives, and non-probate assets, which pass through different rules altogether. The most obvious examples of non-probate assets are insurance policies and employee benefits, which are distributed according to a contract. Even if you have a will which says, I give everything to my cousin Waldo, if your life insurance policy names your cat Cream Puff as the beneficiary, Cream Puff gets the life insurance benefits. The same holds true of an employee pension or a stock benefit plan. Another example of a non-probate asset is any property held in joint tenancy with the right of survivorship. This is true of most joint bank accounts, which you'll find by checking your signature card, and many investment accounts. And although for federal estate tax purposes, by the way, all this property would be considered part of your estate, for state law purposes, here in Texas and in any other state, frankly, it passes outside of your estate and cannot be affected by a will. There are, of course, ways around this, as in the case where you decide to make your estate the beneficiary of your insurance policy, for example. Now, so for your probate assets, what we're talking about, what will happen to them? The fact of the matter is that if you don't have a will, the state of Texas, under the Texas Estates Code, will determine what happens to your property according to state intestacy law. Intestacy, of course, simply means without a will. In case you don't leave a surviving spouse, it's really pretty simple. Everything goes to your children, if you have any. If you don't have any children, it all goes to your parents. If one or both of your parents predeceases you, that share goes to your brothers or sisters, and if none of your brothers and sisters survive, then to your relatives. Well, that may not seem all that simple after all, but frankly, it gets a lot more complicated if you leave a surviving spouse. Because in that case, you have to figure out what in your estate is separate property, that is, property you brought into the marriage or was given or bequeathed to you during the marriage, and what is community property, that being everything else. Then your separate property is divided up in different ways according to whether it is personal property or real property, and the community property is divided up differently. Obviously, since community property is half of the husband's and half of the wife's, the surviving spouse gets his or her share, but the property left over after that share is divided up. The fractions can get really complicated, especially in blended families. So, most people, when asked who they would like to have their property when they die, would normally say, well, it should go to their surviving spouse, and after that to their children. The important thing to know about Texas intestacy law, what happens without a will, is, and intestacy law, frankly, all over the country for that matter, is that it just simply won't work that way without a will. The state of Texas will divide your property up according to the estates code. In many, if not most cases, that is probably not the way you would like things to go. And yet 70% of people in the state of Texas die without a will. And that's the way it goes. Yes, your money can go to your heirs, but only after they go through a determination of heirship and administration, which requires a lot of unnecessary time, effort, and expense. And it's not just estates with a lot of assets or money. Smaller estates can be just as complicated and a lot less cost-effective to deal with. For example, not long ago, a client came to me with a problem. A widow owned a small house worth $80,000. He wanted to buy it, and they were going to close on it tomorrow, but they just found out, oh, wait, her husband had died in 1984 and was still on the deed. Well, first thing I told him was, dude, I'm afraid you're not going to be closing tomorrow. Just trust me on that. And then he went off and got some more information. And some months later, he came back to me. They had learned that the husband had 4 children from a previous marriage and 3 children with the second wife, 2 of which were adopted out as babies before the marriage, and 1 of whom was also deceased. I had to inform them they were looking at a minimum retainer of $5,000 to even take on the case, and it would likely cost double that to get it figured out. And of course, no one had any money to spare. So the widow, who could have used that money for nursing home care, could not sell her house, and it would likely wind up foreclosed by the state in a decade or so. Now, that's a shame, right? Often heirs really could use the resources in smaller estates, but without planning, it can not only be difficult, but in some cases practically impossible to obtain them. So let's see how we can avoid that and how to set things up so your estate is handled the way you want. So, the first big advantage of a will, strangely enough, is minimizing expense. You may have heard advertising about how to avoid probate as if it's some sort of a disease, but the only way that saves you any money is if there is planning in place of probate. As a probate lawyer, I don't mind these cases so much. Honestly, I have to spend a lot of time on them, and I have to charge for my time. But I always find it a terrible waste. Everyone knows you can make gifts of property if you want to talk about gifting property. You can make gifts of property under a will. Even if you're single, you might want someone to have your baseball card collection to remember you by, or you might want someone to take care of your pet parakeet. That is the simplest and most obvious reason for a will, what we can all relate to. You want to have a say in what happens to your property. Also, when you have a will, you delegate to one person, your executor, the power to handle debts, collect claims, collect and sell assets, and handle any distributions necessary. As I said, when someone does not have these powers, it gets much more complicated and much more expensive. Your executor can be given the power to manage your estate and distribute your property independent of any court involvement and any supervision, if you so choose. And that's what is ordinarily done. An executor is very helpful in carrying out your wishes, taking care of gifts you may wish to make, and avoiding squabbling among the heirs. Though many people think, and I've heard lots of people say this, hey, no one would want to fight over my property, especially not my family. Everything is different when someone dies. I like to tell people you never know how someone will react to bereavement, and you really need to be kind and give them the benefit of the doubt. People just react to things in different ways, and sometimes it seems really greedy, but they're going through bereavement the same as everyone else. But I have heard again and again, I just can't understand why my brother or my sister or my cousin is acting this way. It always works out better if you can avoid these potential problems before they arise. And there are a few other things you can do with a will that are worth considering. So for the rest of this talk, I'd like to assume the situation of a married couple who either have children now or might have some in the near future. A big question for any couple with children is always, what would happen if both myself and my spouse died at the same time? What would happen if both of you were in an airplane crash and together and left some small children behind? Sure, you have your life insurance would go to the kids, but who would collect it? Who would manage and distribute your property? And above all, who would take care of your kids? Well, with estate planning in place, the answer is fairly easy, because with a well-drafted will, or preferably a separate declaration of guardian for minors, you can provide for guardianship. That is, you name a person or persons whom you'd like to take care of your children for you. You might also want to provide for something to take care of your kids with and to provide for their educations. So most people, when considering how to provide for their children in the best way possible, also would like some say in how the money they're leaving their children is spent. You would do this through creating a trust in your will. That's called a testamentary trust, by the way, if you ever wondered what that term meant, which would direct the trustee, who is the person who would manage the property placed in the trust, to distribute funds only in specific ways and for specific things if you so desire. Often the trustee and the guardian, and sometimes the executor, will be the same person. The directions can be as specific or as general as you like. Most of the wills I draft have some provision like this in them, as a properly drafted and funded trust can provide your children with almost everything you would have wanted them to have: an education, opportunities, a concerned trustee and guardian, almost as if you had been there to give it to them. Of course, most people do not meet their eternal reward together in airplane crashes, leaving minor children alone in the world. So what about the most common situation where one spouse dies first? Well, first of all, there's the problem of providing for the surviving spouse. It is obvious that the loss of a husband or wife is a terrible blow. What many people don't like to think about is the loss of that spouse is also the loss of his or her income. That too can be a difficult blow. The surviving spouse is left with the inevitable expenses associated with death, funeral expenses we actually talked about earlier today, right? Often enormous medical bills. Usually this can be taken care of by insurance proceeds, but after those bills are taken care of, the loss of income still hurts month after month. Also worth considering is the effect a large sum of money distributed all at once might have. I think we talked about that a little bit as well. Depending on your situation, it might be wise to provide for some management of that money instead of simply giving that sum outright. You might have seen in the news how there are quite a few con artists who prey on elderly people. Frankly, I just heard about one just the other day where a client told me he had a relative who had gotten a call from somebody claiming that her grandchild needed immediate hospital benefits, and she had to wire $7,500 to that person. And she did. And it was just a terrible shame, but some people are really vulnerable. Many elderly people are all by themselves. A large lump sum of money in the bank are easy prey for swindlers or persons selling investments of really questionable value. In this case, a marital deduction or Q-tip trust can ensure that her surviving spouse, at the very least, has some assistance and guidance in managing the estate he or she is left with, and that the amounts needed to take care of the surviving spouse can last a long time. And second, the idea of providing a trust for surviving children still holds, because if the surviving spouse then dies, we have to consider the same things we did when planning for both spouses dying at the same time. The surviving spouse may leave behind minor children who still need looking after. And even if the children you leave behind are over age 18, many people still feel uneasy about dumping a large sum in insurance and investment proceeds in their laps all at once. That's where the trust in your will comes in, where your trustee, whom you select, distributes the money and property according to your directions. This can go on for as long as you decide is best for your children. Traditionally, conventional wisdom has been to keep funds protected in trust for as long as possible. That's the way it was when I started practicing law. It was just, you just put it in trust and leave it in trust for their whole lives, and ideally for up to 21 years for grandchildren. But if you're and over the years, I've kind of tended to change my mind a little bit on this because, sure, I understand. If you're wealthy enough, you can set up a family foundation and where your children just don't need to work for the rest of their lives, sure, go ahead and do that. But in most people's cases, they don't have those kind of funds, and you have to think about also negative aspects of long-term trusts, where beneficiaries may never become productive or develop a sense of self-reliance. So it's worth considering all aspects about how long these should last and under what conditions they should be set up. For minimizing estate tax, I think we mentioned estate tax before. They should still be considered, the effects of estate tax, as we mentioned. I think they mentioned what the amount of the exemption is currently. Right now, it's technically $12,920,000 per person. That is an awful lot. It's only a tiny percentage of people that even need to think about that. So that being said, one thing you've got to consider is that as we speak, there are proposals before Congress to reduce that enormously, and that sunsets in 2025. Now, last time that happened before Congress was, I believe, in 2011. And they went ahead and extended it, but you can't guarantee that. The estate tax could drop dramatically. The exemption could drop dramatically within just a few years, and so it's still something we should still be considering a little bit. But anyway, the estate tax normally will have no effect on the estate a surviving spouse inherits, since the Internal Revenue Code provides for an unlimited marital deduction. That is, your estate does not have to pay any tax on property which passes to your surviving spouse. I should point out that for tax purposes, your estate includes anything which passes by reason of your death, including the non-probate assets I talked about earlier, like insurance proceeds and joint bank accounts. That is all included and taxable, but in any event, the surviving spouse will not have to worry about paying any estate tax. That is a different story down the road, though, for the kids, who ordinarily wind up with the whole estate. And for those who would like to minimize or eliminate the taxes paid to Uncle Sam and maximize the amount going to who you want, one way to do this is, again, through using trusts. You only give outright to your surviving spouse just enough to reduce your estate tax to zero and give the surviving spouse the use and benefit of that property during his or her lifetime. These trusts are called by several names. You've probably heard of them: a bypass trust, an AB trust, or a credit shelter trust, but they're all the same thing. They legally pass some property to your children on your death, and while still allowing your surviving spouse to reap the benefits of it. And it is all perfectly legal and sanctioned by the Internal Revenue Code. So we're not talking about any shady ideas here. And there are other techniques for reducing estate taxes, including lifetime gifts, charitable gifts, and what are called generation skipping transfers, which should be used as an overall plan involving a large estate. Now, as Anna and Michael talked about in more detail, another aspect of estate planning is how one can make an impact by charitable gifts in your will or trust. Sure, as I said, today's estate tax exemption is currently pretty large. There are not many people affected by that, but many people do fail to consider that often a lot of the estate you may be leaving your children consists of qualified money. That is, pension plans like IRAs and 401k accounts where all of these assets will result in your heirs paying income tax on the whole amount. I just wanted to re-emphasize what Michael was talking about, because it's not just a matter of stretching things out. It's a matter of avoiding those income taxes entirely and getting much more bang for your buck in your estate by by being able to use that charitable option. You can also set up lifetime charitable trusts, which we also talked about, where you can continue to receive benefits from assets during your lifetime, but leave the remainder to a church or other charity, which allows you to get some tax benefits now for that gift. Now, there are many other goals which can be accomplished through the proper and legal use of wills and trusts, but these depend on your personal situation. All of them depend upon what your goals are, what your estate will consist of, how big your estate will be, and other aspects, and I can't really make any particular recommendations without knowing those particulars. But we've gone through some scenarios and discussed why pretty much everyone should have some estate planning in place, even for small estates. Got it, right? I should have a will. But why can't I just do one for myself? I mean, after all, there are forms online showing how to draft your own will, right? And it'll all be perfectly legal and enforceable. And we've all seen ads all over for stuff like LegalZoom. Some of these are pretty good, but they're all limited by the fact that they can't take into account your own unique situation. And also, it is very easy to overlook something and get something just barely wrong. As a simple example, it is perfectly legal to write your own will in your own handwriting. That is just as enforceable as any will drawn up by a lawyer. It's a lot easier to call into question, though, and have its validity challenged. I like to, my favorite example of this dates all the way back to law school, where Professor Johansson told us about this case where there was a testator out in the state of California, and he had an estate on the side of a mountain that he was really proud of. And he called it Cragthorne. In fact, he had a stamp made up with Cragthorne on it that he would put on letters. That's where he was sending it from. And so he wrote out his will all in his own handwriting, and it was really comprehensive. He named his executors, he set up things for them, and he even described his property with the full legal description. The whole meets and bounds thing. Here's the full legal description. This is the property known as, but he couldn't help himself. He got to a certain point and he took his rubber stamp and went Cragthorne on the will. That's what it's called. And the court threw it out. Said, no, it's not a valid will. It's not all in your handwriting. Now, that's kind of ridiculous. And frankly, our Texas courts would have come to a little different conclusion and probably would have been all right with it. But it's a fun example of how, even though you can try very hard, it's very easy to get something just barely wrong. And even if you do write an effective and enforceable will, in order to get it admitted to probate, your executor or another person with an interest in your estate will have to get witnesses to testify in court that this is in fact all your handwriting. This is not necessarily all that difficult to do. I've had it done myself, but can be a problem if there's someone out there that might want to challenge the will. Here nowadays, in a properly drafted will, most of the problems in proving it up to the court can be avoided by the use of what is called a self-proving affidavit. That's simply an affidavit attached to the will in which the witnesses swear that everything was done correctly at the will signing. The witnesses watched the testator sign. The witnesses are over age 14. The testator was of sound mind, and so on. The advantage with this is that the will is then considered by the court to prove itself, and no testimony is necessary to have it approved. In Texas especially, since we have very progressive probate laws, this is a quick and easy process. Now, but a colleague of mine once said to me, and I like telling people this because I like the idea, he said, clients will ask him, why should I pay you when I can get a trust online for $400? And he said, well, you can get a wife that way too, but I really wouldn't recommend it. So, and finally, I'll let you in on a little secret. Lawyers that handle probate matters actually like people who use form or LegalZoom wills. I've probated actually quite a number of those myself over my career, and it's weird because I can attest every single one of those that I probated has always had some flaw, some additional problem created that we didn't anticipate. Either it's verbiage or something was put in the wrong place, or there's always something a little wrong that complicates things a little bit more. So it always makes the process a little bit more complicated and expensive. I mean, I really understand. I mean, I personally try to be really responsible in spending money myself, and I look for bargains whenever I can. But saving a few $100s by using a form will, in my personal experience, winds up costing a lot more in money, not to mention time, when that will is actually put to use. So, obviously, we could talk a lot more about features of wills and what they can and cannot do for you, but my time here is limited. Before I wrap up, I'd like to take a brief look at a few other techniques used in estate planning. Now, first, a lifetime revocable trust. You have probably heard a lot about this technique already, which is simply where you place all of your property into a trust and can take it back at any time. There are certain things a trust like that can do for you that are worth looking into. Number one is providing for incapacity of a spouse. First, the one thing a will can't do is take care of problems which may come up during your lifetime, such as where one spouse cannot act for him or herself and has property or investments which need management. Without any planning, you generally have to go through guardianship proceedings, which are lengthy and expensive. One way to handle this is through placing your assets into a revocable trust, which names you and your spouse trustees, and if one of them becomes incapacitated, the other can act as trustee to manage the property alone. This is sometimes helpful if where, for example, property is held in the names of both husband and wife, might have to be sold or investments need to be managed. I once had a lady consult me in a panic. Her father ran a small business and he'd been in a motorcycle accident and they had nobody else that could sign off on getting payroll made on Friday, and his business would fail unless they made payroll. And that was a really difficult situation because the only legal result was to go for a temporary guardianship, and that is really, really expensive. So, but there are other ways of accomplishing this through powers of attorney as well, which we'll touch on as we wind up. Another, and often the best, one of the biggest reasons that I will recommend revocable trust to clients is when you have any real estate in another state. If you only have a will, in order to transfer that property in the other state, an ancillary probate proceeding has to be brought in that state, and that can really drive up costs enormously. Placing the title in a revocable trust avoids that expense and makes asset transfers simple. Third, there are ways to shelter some assets from liability. I'm going to kind of skip over that because we're running a little short on time, but there are ways to allocate assets between spouses so that things like the homestead and assets that are not vulnerable can be allocated to the non-vulnerable spouse, and you have a partition agreement and can make things a little bit safer for people that are liable for potential, that have potential major liability. Moving on to tax aspects, another advantage of a revocable trust is that, and the reason it is revocable in the first place, is that it does not constitute a taxable transfer when you move your property into it. Moving the property, so that avoids the necessity for filing extra tax returns for the trust. On an irrevocable trust, you'd have to file an annual 1041. Revocable trust, nothing changes. And properly drafted revocable trusts also allow for retaining the homestead and elder property tax exemptions for your residents that you can place in there. Privacy can also be an issue when it comes to probate. A will, when probated, is usually a matter of public record. And a lot of people don't like that idea. They don't like the idea that people can see what they put in their will. Well, as a practical matter, though, honestly, it doesn't really matter unless your name is like Michael Jackson or something. Nobody really pays attention to those things. But in certain cases, when people, let's say they have a special needs child that needs special provisions when they die, that doesn't apply to their other children, and they'd rather people don't find out about that. They'd rather that be kept private. In cases like that, you might want to consider something like a revocable trust to be able to maintain that level of privacy. So, and also generally avoiding probate. The most common use of it is avoiding probate because a revocable trust becomes an entity in its own right that keeps right on going after the death of one of the grantors or both of them, and can be amended also easier than a will. But the catch on that is when people think about revocable trusts, they oftentimes don't think about the fact that all of your assets need to be placed in that trust in the first place. That means all your investment accounts, your bank accounts, your personal property, your real estate, and even your vehicles, technically speaking. But they have to be maintained that way through the rest of your life. And that can be difficult. You have to accustom yourself to doing things a little bit differently the rest of your life. A lot of people are fine with that. A lot of people don't really want to go to that trouble. So that is kind of difficult to do without professional management. You also need to make sure you have in place what is called a pour-over will, just in case there are some assets that don't make it into the trust, and then you have to probate a will anyway to get them there. So as an alternative to this, the process of probating a will, as I mentioned, popular media may depict it as being terribly expensive. It's not as big a deal in Texas as it is in some other states. So especially with the independent administration, where mostly all the executor needs to do is prove up the will in court, which normally proves itself, as we said earlier, and then file an inventory of the property and claims of the estate. That allows for a lot of flexibility. Now, a brief look at irrevocable trusts. These are trusts, in fact, we've talked about some of them earlier. They talk about charitable remainder trusts. Those are irrevocable trusts. These are trusts where the grantors or settlers or trustors cannot get the property back. These are used for more specialized goals, such as where one wants to set up an unbreakable and protected source of income for a loved one during one's lifetime, whether it has a charitable remainder or not. They can also have their estate tax uses too, as in a so-called crummy trust, which is not a bad trust, but is rather named after a tax court case, which is usually used to hold a life insurance policy on behalf of one's children so that it is not taxed in that person's estate at all. There are a whole galaxy of other specialized irrevocable trusts like CRATs, GRATs, CRUTs, and GRITs, which can be helpful in tax planning for large estates. And of course, the charitable remainder trusts we've discussed earlier can give you income benefits, tax benefits now, while retaining income from property during your lifetime. So the major difference to go away with between revocable and irrevocable trusts is that irrevocable trusts are taxable creatures in their own right. If a revocable trust is like a partnership, an irrevocable trust is like a corporation. So for an irrevocable trust, there are greater administrative costs and tax return requirements. The flexibility is not as great, and because you cannot just put in and pull out property and cannot amend the trust whenever you would like to. Now, there are some other tools used in estate planning which really should be part of everyone's estate plan that I'll just go through really quickly. Durable powers of attorney for you and your spouse. Allow one spouse to act as the other's attorney in fact, handling assets, transferring real estate, managing investments, and the like. If one spouse is so incapacitated that he or she cannot act for him or herself. They're called durable because a regular power of attorney automatically terminates when somebody becomes incapacitated. In any event, you need to be able to take care of the ill or incapacitated party without having to worry about having to file suit to have him or her judicially declared incompetent and getting a guardian appointed by the court. Second, a medical power of attorney allows you to name who will make medical decisions for you if you cannot make them yourself. Ordinarily, a hospital will ask you to sign one of these upon admission, but in case you're not able to sign one, think about it. What if you're in a car wreck and in a coma? You get carted into the hospital, you can't sign one of the forms they're giving you. You should have these available to, just in case, to name who you would want to make these decisions. Third, many people nowadays are concerned about the possibility of being in a coma and kept on life support forever, causing a lot of heartache and draining a family's resources. We talked about that in the Catholic context. As our physician already explained to you, there are certain things that we as Catholics are not supposed to be doing, but removing artificial life support in the case of somebody that is terminally ill is perfectly okay and subject to your own decisions. These directives to physicians can be set up to make your own decisions and instruct your heirs exactly how you would like these situations handled. And one thing I'll also point out is that there are specifically Catholic versions of the directive to physicians and the medical power of attorney, if you so choose, that can directly reference Catholic doctrine. I have them available for clients to go one way or the other. Fourth.
Mike, I'm sorry, I was just going to tell everybody.
Oh, sure.
On the left-hand side of your packet is a resource page, and all of the directives that Mike was talking about, the Catholic directives, the St. Thomas More Society here locally put together Catholic powers of attorney and directives to physicians. The link to those is available on that resource page.
Yeah, and that's where I got my forms in the first place, because I'm part of the St. Thomas More Society as well, obviously. Fourth, with strict legal requirements now in place about disclosing medical information when a loved one is in the hospital, it can be impossible for family members to find out what is going on with their loved one's health and treatment. Signing a HIPAA authorization in advance makes sure your loved ones can be kept informed. As in the case of the medical power of attorney and the directive to physicians, often a hospital will ask you to sign one of these upon admission, but it is better to have one prepared in advance. Fifth, one potential loophole in the estate planning process is if you ever get to where you cannot take care of yourself, someone may have to be appointed your guardian to care for you and manage your estate. And sometimes people are concerned that the black sheep of the family can do this to them. If you have a declaration of guardian in place, though, you can specify exactly who you would want to act as your guardian, and sometimes who you would say can never act as your guardian, and that can be very handy. Sixth, another thing is a lot of people don't know about is an appointment of agent for disposition. Most people don't think about this. This is somebody who has the authority to make decisions regarding your bodily disposition. That means the person to sign off with the funeral home, which we already talked about earlier, saying whether cremation or burial and how the funeral is supposed to go. Usually there's a surviving spouse or surviving children that can handle this, but sometimes having someone in place designated a decision maker can be a real burden off your family. It is much flexible. Some people provide for them in your wills, but it is better to have them in separate documents. Finally, many people would like to go into more detail about what anatomical gifts they would wish to make, or make it clear that they do not want to make an anatomical gift. An anatomical gift declaration helps clarify their wishes. So in conclusion, I hope I've given you a few things to think about in your estate plan, and perhaps shown a few things you might look into for your own situation. As I said, I can't make any specific recommendations without knowing someone's situation and goals. I hope that knowing a few of the things that are available can be some help to you. Thank you for your time and attention, and I'll be glad to answer any questions you might have. Yes?
I've got a question. Can you talk a little bit about trying to probate a copy of a will because you lost the original will?
Yep. The difference there is that there is a presumption in the estates code that if you cannot find the original of a will, that it has been revoked, because a will can be revoked by tearing it up and throwing it away. So that's a presumption. So you're going to need to have testimony and proof that the testator did not wish to revoke his will, and that the copy of the will should be admitted as the original. In most cases, all that really means is finding a separate witness to attest to that, and somebody to attest to the testator's handwriting. It's going to be a little bit more difficult in Dallas County, but I've done several of these. Collin County, Judge Copeland is really cool with copies of wills, so it's very easy to do in Collin County, but it's usually not a problem. You just have to have the evidence on hand, and it's just kind of a few extra steps to do.
It cost me $3,000 in Dallas County.
Really?
Yeah.
Wow. That seemed kind of difficult, but yes. I think, oh, yes. Somewhere here.
So can you explain the pros and the cons of having the co-executors, co-trustees, co-this and co-that?
Pros are you have some balanced in terms of somebody not going off and making wild decisions that other people get upset about. Cons are generally, I do not recommend it ordinarily because it makes it much more difficult to administer an estate or administer a trust when you have two people that have to agree on everything. I can understand situations where they're useful, but as I said, it just makes things a little bit more complicated. You've got to remember that executors, trustees, and powers of attorney are all acting in a fiduciary capacity, meaning they have legal responsibilities to act on for the benefit of people that they're acting for. And so if you need to bring them into court because they're not doing that, you can do that. So I can see where they're useful, but sometimes, mostly I don't generally recommend it. That's true, yeah. Yes.
Well, that kind of feeds my question, is the pros and cons of if you have executors out of state.
It used to be a big problem. It's not as big a problem as it used to be, frankly. The biggest problem it used to be, frankly, was having to get the executor to come into town to go to the hearing. Because even if you've got a really perfect will and it's completely self-proved and you've got the original and you file it with the court, you still have to come in for the hearing date. And if your executor is in Rhode Island or something like that, that may be kind of a big pain in the neck. But nowadays, after the whole COVID thing in the last few years, courts are still moving on and a lot of them are having hearings via video conference. And if that is the case, like right now, I just filed a will for a client. The client is in El Paso, and I'm just going to do a video. Just do a video conference for the hearing, and he should never have to arrive here. It's a little bit more complicated because you do have to get originally signed documents from him back and forth, but that can be done with FedEx if you need to. It's not that big of a deal as much as it used to be.
We have one last question.
Sure.
Oh, how about the pros and the cons of filing your will with Dallas County so it doesn't get lost?
I don't know that I'm all that big a fan of that, and I guess the reason is that if you file your will with a county, you don't have to notify anybody of anything. And what happens if you file your will in Dallas County and then you wind up being moved into a nursing home in Austin, and then this person dies and they're just like, where's the will? I don't know. Are we going to have to check all 255 counties in the state of Texas to find that? If you do that, you want to make absolutely sure that lots of beneficiaries know, okay, this is where my will is filed, and so that they can access that readily. But I don't normally recommend that. But it can be a decent practice. At least you do know that it's been filed. So. Yeah, that way you won't lose it, because heaven knows I've run into so many situations where people say, we just lost the will, we don't have the original, we've just got a photocopy, or sometimes don't even have the copy. People don't take care of those things.
If you do have your will with the county, it's on file, and you die, do you have to wait until you get the letter of testament in order to get it?
You don't ever get it, no. I'm sorry, she asked if you have your will on file with the county, do you have to get letters testamentary before you can get it back? And number one, the only way you get letters testamentary is by filing the will for probate. And number two, when you file the will, whether it be in the process of probate or whether it be before you die, you never get it back. The best you can do is get certified copies. Yep. The original stays with the county forever. You can get certified copies if you need to probate it elsewhere.
Because I thought when they told me that way, if something, something happened to you, they would be able to get to the will instead of having to wait till you go through probate to get it out of your lockbox.
Oh, that's a whole different issue. If you have a lockbox that is not accessible by your heirs, you can file a motion with the court to get an order to open that safe deposit box and see if there's a will in there. That's kind of a separate proceeding that might have been what they were talking about. But if you have just general advice, if you put your will in a safe deposit box, make really sure that someone else has access to that box other than just you and your spouse. So, okay, thank you.